Man, the L's are really rolling in for New York lately. It's almost as if everything they try to do surrounding guns is unconstitutional and they're a bunch of power-grabbing tyrants with a moral superiority complex. Clearly, the height of their ivory tower up in the clouds has put them out of touch with the laws of the land and the lives of the constituents outside the big city bubble, and it's nice that judges are starting to hand them their butts. But before I get into this latest to a victory, today's video is brought to you by Blackout Coffee Company. They roast everything fresh to order in sunny Florida and have a great selection of coffees, teas, and hot chocolates, including special roasts that help out organizations like Firearms Policy Coalition and Gun Owners of America directly. To check them out, use my link down in the description. Today's win is around New York's red flag law and could have some pretty big implications elsewhere. Judge Craig Stephen Brown has ruled that the law is unconstitutional because it's not within a court's scope or expertise to determine mental health issues. The decision is likely to be appealed, but is based on some very sound logic. And I say that not just as a gun owner, but as a duly licensed mental health therapist that was practicing right up until a week before the baby was born. The case was brought to the court by Corey J. Monroe, who found himself on the wrong end of a firearm seizure order after allegedly pointing a loaded shotgun at a neighbor during an argument. He denied these allegations and called on the courts to dismiss the order against him. Meanwhile, New York has recently been under a swatting epidemic, of all things, for whatever reason, forcing dozens of schools to close under fake reports of active shooters, bomb threats, or other armed and dangerous individuals. The state had 50 swatting calls in just one day alone earlier this week and had 36 last Friday. Hochul has suggested that the calls are computer-generated and coming from overseas, but if nothing else, it proves people can't be trusted not to make frivolous calls and accusations to get people in trouble. Which is nothing new if you've been watching the degeneration of society. Under Mental Health Hygiene Law 9.39, a person's liberty rights cannot be curtailed unless a physician or mental health professional thinks that a person is suffering from a condition likely to result in serious, imminent harm to themselves or others. Every state has a law like this. In Massachusetts, it's called Section 12. In South Carolina, I couldn't tell you because I never had to use it. But it can't be initiated by a neighbor or an ex-wife or an old roommate or anyone not a trained professional. Red flag laws try to bypass that law and take away people's guns without due process. I've done whole videos and guest speeches on this topic. Frankly, I'm surprised this guy even got his day in court, as some states don't even have a process for that outside of folks wealthy enough to have a lawyer on retainer. Seriously, in some states, if you can't afford a lawyer to fight this, you can't fight it because they won't appoint you one. Anyway, Judge Brown pointed out that New York's red flag law doesn't require any input at all from a doctor or mental health professional prior to confiscation. None. Zilch. Instead, the courts are asked to pass judgment on a person and their mental fitness with no expertise in mental health and no expert witnesses or opinions to guide them. Which does not sound like due process. He wrote that Second Amendment rights are as fundamental as Fourth Amendment rights and so must also be subject to due process. Accordingly, this court joins the Monroe County Supreme Court in holding that, under CPLR 63-A, in order to pass constitutional muster, the legislature must provide that a citizen be afforded procedural guarantees, such as a physician's determination that a respondent presents a condition likely to result in serious harm, before a petitioner files for a temporary extreme risk protection order or extreme risk protection order. Since this standard is required to prevent a respondent from being deprived of fundamental rights under the mental hygiene law, then anything less, as contained in 63-A, deprives a citizen of a fundamental right without due process of law. This court declares New York's extreme risk protection law to be unconstitutional. So thank you, Judge Brown, for standing up to New York and for the people. That's it for this happy little video. Thanks everyone for tuning in. Please give a like, share, and subscribe if you are new here. And as always, happy shooting.